Welcome to the deep dive. Today we're tackling something absolutely fundamental, the edges of the First Amendment. Everyone knows about free speech, free press, but where does the Constitution actually draw the line?
Exactly. It's not just about what's protected. We're zeroing in on where those rights bump up against legitimate government interests. Think schools, your workplace, even just posting online. What isn't covered is just as important as what is.
Right. So our goal here is to take all this complex court language, all these famous cases, and make it, well, practical. Understand the tests the Supreme Court uses so you know the rules of the road.
And I think the big surprise for many people is just how not absolute these rights are. It's this constant balancing act. What you say might be protected here, but not over there. Context is everything.
Okay, let's dive into that. Section 1. Where does speech actually lose its protection? Let's start with something really common online and off saying something false that harms someone's reputation. Defamation.
This is ground zero for a lot of legal battles. And the core idea stemming from that huge case, New York Times v. Sullivan, is that public debate needs breathing room. If every single error about a public official led to a lawsuit, well, nobody would criticize anyone.
So we have to tolerate some mistakes in the name of free discussion. That gave us the actual malice standard.
Yeah.
How does that work if, say, you're blogging about your local mayor?
Okay, so if you're talking about a public official, mayor, senator, police chief, or even a public figure, someone really well known, they can't win a defamation suit against you just because you got a fact wrong.
They need more.
Much more. They have to prove actual malice. And crucially, this does not mean you just dislike them or were angry.
Right. That's a common confusion. It's a legal term of art, isn't it?
Precisely. Actual malice means you knew the statement was false when you made it, or you acted with reckless disregard for whether it was true or false. Like you had serious doubts, but published anyway.
That sounds incredibly hard to prove for the person suing.
It is, by design. It shields the press and, frankly, all of us when we're discussing public matters. It encourages robust debate without constant fear of lawsuits over honest mistakes.
Okay, that covers factual statements. But what about opinions? If I write online, in my opinion, that council member is totally corrupt. Am I safe just because I said, in my opinion?
Another really important nuance, the Supreme Court addressed this. There's no magic shield just by slapping opinion on something.
So you can't just hide a factual claim inside an opinion statement.
Exactly. The real test is whether that statement, even phrased as opinion, implies an assertion of fact that could be proven true or false. Saying, in my opinion, the mayor embezzled funds implies a factual claim embezzlement that can be investigated.
But saying, in my opinion, the mayor's policy is terrible.
That's likely protected opinion. It's subjective judgment. It can't really be proven true or false in a courtroom. Think pure hyperbole, name-calling, harsh criticism that's generally okay. It's statements that sound like facts, even if dressed up as opinions that get you into trouble.
Got it. So verifiability is key.
Yeah.
Okay, let's shift gears from reputational harm to physical danger. Speech that might incite violence. The standard here has evolved quite a bit too, hasn't it?
Oh, massively. We've moved way past the old idea of just banning speech because it had a dangerous tendency. The court's very clear now. Speech that makes people angry, that invites dispute, that's often the whole point of the First Amendment.
Stirring the pot is protected then?
To a large extent, yes. The limit is only reached when the speech is, and this is the key phrase, likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience.
Okay, clear and present danger and serious substantive evil. That sounds like a really high bar. It has to be imminent, right? Not just a possibility.
Imminent and serious, not just making people uncomfortable or angry. This is crucial for distinguishing passionate political speech from what the law calls a true threat.
Which is so relevant today with, intense online rhetoric. How does the court tell the difference?
Context is vital. Look at the Watts case. A young man at an anti-war rally said something like, "If they make me carry a rifle, the first person in my sights is LBJ." He was convicted, but the Supreme Court overturned it.
Why? That sounds pretty threatening on his face.
Because of the context. It was conditional, "if they make me," said during a political protest, and the court saw it as crude, inappropriate, yes, but ultimately political hyperbole, not a genuine plan to harm the president. It lacked believable intent.
So the setting, the audience, the exact words, the tone, it all matters in deciding if it's just venting or a real threat.
Absolutely. Which brings us to a related category, fighting words. These are different from true threats.
How so?
Fighting words are defined as words that by their very utterance inflict injury or tend to incite an immediate breach of the peace. The idea is they are so insulting, so personally abusive face-to-face, that they're likely to provoke an instant violent reaction from the person they're addressed to.
Like yelling an insult right in someone's face to start a fight.
Exactly, and the court views them as having very slight social value. But it's crucial to note, this doctrine is applied very narrowly today. Given the strong protection for even offensive speech, it's rare for a conviction based purely on fighting words to stand unless it's that direct, personal, immediate incitement to brawl.
Okay, so we've covered false speech, dangerous speech.
Yeah.
What about speech banned for reasons of morality, specifically obscenity?
Right. Governments have always had more power to regulate obscenity, but the legal definition is incredibly narrow, defined by the Supreme Court. It's not just anything sexually explicit, but interestingly, one of the strongest protections here is actually about privacy.
You're talking about Stanley v. Georgia.
Precisely. That case established a fundamental right to receive information and ideas in the privacy of your own home. So generally, the government cannot make it a crime to simply possess obscene materials at home.
So they can regulate selling it, distributing it, but not just having it for personal viewing.
Broadly speaking, yes. The court drew a line around the home, saying the government can't be the thought police controlling what you read or watch privately. It's a powerful statement about individual autonomy.
But, and this is a huge but, there's one category where that privacy shield completely disappears.
Yes, and it's vital to be clear. This protection absolutely does not extend to child pornography. The government's interest in protecting children from sexual exploitation is considered paramount and overrides any privacy interest in possessing such material. There is no right to possess child pornography.
That makes sense. Now, this tension between access and protection also plays out in public places, like libraries offering internet.
It does. The Children's Internet Protection Act, or CIPO, requires public libraries getting federal funds for internet to use filtering software to block obscenity and child pornography.
And libraries push back, arguing these filters inevitably block perfectly legal, constitutionally protected websites too, right? The over-blocking problem.
They did, but the Supreme Court upheld CIPO, partly because they didn't see library internet access as a traditional public forum, like a park, giving the library more control. But the key reason it was upheld, and this is important for you as a user, is the requirement that libraries must have a mechanism for adult patrons to easily disable the filter upon request for accessing constitutionally protected material. If the filter blocks a legitimate health site, for example, you should be able to ask for it to be unblocked quickly. That escape hatch saved the law.
Okay, that covers expressive limits. Let's move to the right to associate gathering, lobbying, joining groups. This is tied directly to free speech, isn't it?
Inseparable, according to the court. Freedom of association protects our ability to band together for political, religious, social, cultural goals. Think about the civil rights movement, the NAACP v. Alabama case, where Alabama tried to force the NAACP to reveal its members, showed how vital protecting association is. Disclosure could lead to harassment and reprisal.
So it protects the group's ability to function. Does it also protect a group's right to decide who can join? This idea of compelled association.
Yes, it can. This was the issue in Boy Scouts of America v. Dale. The court said that forcing an organization to accept members whose presence significantly interferes with the group's ability to advocate its particular viewpoints can violate its freedom of expressive association.
So if including someone fundamentally changes or undermines the group's core message,
then the group might have a First Amendment right to exclude them. The Boy Scouts argued their message on certain values would be compromised, and the court agreed in that specific context. It's about protecting the group's voice.
Okay. Going back to those membership lists, like in the NAACP case, is that associational privacy absolute? Or can the government ever force disclosure?
It's not absolute, but the bar is high. Compelled disclosure is seen as a serious burden because, as we said, it can chill association and expose members to harm. However,
There's always a however.
right, it can be outweighed by a sufficiently compelling public need. The classic example involved President Nixon's presidential papers.
Ah, the Watergate tapes and documents.
Exactly. While Nixon argued releasing certain records would infringe on the associational privacy of people mentioned, the court found that the government's interest in preserving historical records and ensuring accountability was so strong that it overcame the privacy claim in that instance. It's rare, but possible.
Let's talk about associating to influence the government lobbying and petitioning.
The right to petition is incredibly broad. It's not just writing your congressperson. It covers accessing courts, administrative agencies, asking the government to take actions that help your group. It's the whole process of trying to get the government to do something.
But because money and influence are involved, lobbying can be regulated, can't it?
Yes, absolutely. Congress can and does require paid lobbyists to register and disclose things like who hired them, who's paying them, how much they're spending. This was upheld way back in United States v. Harris.
And the justification isn't to limit speech, but
to ensure transparency and protect the integrity of government. It allows the public and other officials to understand the pressures being put on lawmakers. It's regulating the conduct of lobbying, not the message itself.
this leads to a really interesting doctrine for businesses, the Noer-Pennington doctrine, immunity from antitrust laws for lobbying.
That's right. It's a major protection. Basically, if competitors get together specifically to petition the government, maybe lobby for a law that helps their industry, even if it hurts another competitor, they generally can't be sued under antitrust laws for that joint activity.
Wait, so my company and my biggest rival can team up to ask Congress for favorable regulations, and we're shielded from collusion claims?
If the goal is genuinely to influence government action, yes. It stems directly from the right to petition. But there's a critical exception, the sham exception.
What makes it a sham?
It's a sham if the lobbying or the lawsuit isn't really about trying to get the government to act, but is just a pretext to directly interfere with a competitor's business, using the petitioning process itself as a weapon to harm a rival, rather than achieve a policy goal. If that's the intent, the antitrust immunity disappears.
Got it. So genuine petitioning is protected, weaponizing the process isn't. Okay, still an association. What about public employees? Can you be fired just for belonging to a certain group?
Historically, that happened guilt by association, but the Supreme Court put strict limits on that. You can't be fired just because you're a member of an organization, even one with some unlawful goals.
What does the government have to prove then?
They have to prove you, the employee, had the specific intent to further the organization's illegal aims. Just being a member, even knowing about the illegal goals, isn't enough. You have to actively share the unlawful purpose.
And what about political affiliation? Can government jobs be handed out based on party loyalty, the old patronage system?
That's been largely dismantled by the courts, too. Generally, government employers cannot hire, fire, or promote based purely on political affiliation. It infringes on core First Amendment rights of belief and association.
Is there any exception?
Yes, for certain high-level policy-making positions where political loyalty might be considered essential for the effective implementation of the administration's policies. But for the vast majority of public jobs, political affiliation is not a permissible basis for employment decisions.
Okay, let's shift to Section 3. This is where the government isn't regulating our speech, but acting as a speaker itself, or attaching strings to the money it gives out.
Right. And when the government speaks for itself, it has very broad attitude.
Yeah.
It can promote recycling, discourage smoking, fund art. It doesn't have to be neutral or fund opposing views.
But there's a line between the government persuading people and forcing them, right? Coercion versus persuasion.
That's the critical line. The government can try to persuade private parties to adopt its views, but it can't coerce them into silence or adopting its message by threatening punishment or regulatory action if they don't comply.
Can you give an example of where that line might be crossed?
Well, think about a situation where a government official, maybe unhappy with a group's political stance, starts leaning on banks or insurance companies, suggesting they should cut ties with that group or face regulatory hassles. That moves from expressing disapproval, persuasion, to using government power to suppress speech, coercion. The Vullo case involving the NRA touched on these kinds of allegations.
Okay, that makes sense. Now, what about funding? This affects so many nonprofits, universities, researchers. Can the government put conditions on grants that limit speech?
Yes, but again, there are crucial distinctions the court makes. It depends on what kind of condition it is.
What's the key difference?
The court separates conditions that simply define the limits of the government-funded program itself from conditions that try to leverage those funds to control the recipient's speech outside the scope of that specific program.
Okay, let's unpack that. What's an example of just defining the program limits? The Rust v. Sullivan case is often cited.
Right. In Rust, the government funded family planning clinics under Title X, but said the federal money couldn't be used in programs that counseled about or referred for abortion. The court said this was okay.
Why?
Because the government wasn't telling the clinics they could never talk about abortion with their own private funds. It was just saying this specific federal money is for non-abortion family planning activities only. It defined the scope of the subsidized project.
So that's a constitutional condition. What's an unconstitutional leveraging condition?
Look at the Aid v. Alliance for Open Society case. Organizations getting U.S. funds to fight HIV/AIDS overseas were required, as a condition of funding, to adopt a formal policy opposing prostitution and sex trafficking. And this policy had to apply to all their activities, even those funded privately.
So it reached beyond the government-funded project.
Exactly. The court struck that down. It said the government was leveraging the funding to compel these organizations to adopt the government's viewpoint as their own across the board, even in their private speech. That crossed the line from defining a program to coercing a specific message.
That's a really important distinction for anyone taking government money. Okay, one more area: compelled speech. Disclosures, like warning labels or professional notices.
Right. And generally, if the government requires disclosure of purely factual, uncontroversial information, think calorie counts on menus, or a lawyer having to state their license that faces pretty low scrutiny, it's usually seen as fine, promoting transparency or consumer protection.
But when does that kind of compelled disclosure become constitutionally problematic?
It gets tricky when the required disclosure isn't just factual and neutral, but forces the speaker to convey a specific message on a controversial topic, especially one that goes against their own core beliefs or mission.
The Nifla v. Becerra case about crisis pregnancy centers seems relevant here.
Exactly. California required licensed centers, most of which oppose abortion, to post notices telling clients how to get state-funded abortions and contraception. The state argued this was just factual information.
But the court didn't see it that way.
No, the majority applied higher scrutiny. They found that forcing these centers to essentially advertise state-subsidized abortion services, a procedure fundamentally at odds with their mission, wasn't just relaying neutral facts. It was compelling them to deliver a government-drafted script on a deeply controversial issue, altering the content of their own speech.
Because the message itself was the point of contention?
Precisely. It wasn't seen as uncontroversial factual disclosure, but as compelled speech on a divisive topic, which triggered stricter First Amendment review.
Okay, this brings us perfectly into Section 4, putting all this into everyday context. Because where you are and who you are changes everything. Let's talk about physical spaces. First, public forums.
Right. The analysis starts with the type of space. The most protected are traditional public forums. Think public parks, sidewalks, town squares, places historically used for assembly and debate.
And the rule there is maximum freedom.
Pretty much. The government can impose reasonable restrictions on the time, place, and manner of speech, like limiting noise levels late at night or requiring permits for large marches. But crucially, these rules must be content neutral.
Meaning they can't target the message itself.
Absolutely not. The government cannot favor one viewpoint over another in a traditional public forum. The classic example is Police Department of Chicago v. Mosul. The city banned all picketing near schools except labor picketing.
That sounds like picking winners based on the subject matter.
Exactly. The court struck it down as blatant content-based discrimination. You can't allow labor protests but ban civil rights protests in the same location. That's unconstitutional.
Okay, so parks and streets are wide open, relatively speaking. What about other government property? Like, say, the inside of a courthouse, a military base, or even that library internet access we discussed.
Those are usually classified as non-public forums. The government has much more control over speech in these places because they haven't been traditionally opened up for public expression.
So what's the standard for rules in non-public forums?
The rules only have to be reasonable, and this is still important, viewpoint neutral. They can restrict speech based on the subject matter, like banning all political campaigning inside a polling place, but they can't allow campaigning for one candidate but not another. That would be viewpoint discrimination. Reasonableness is a much lower bar than the strict rules for traditional public forums.
Got it. Now, context that affects millions: schools. What are the speech rights of students?
This is huge for parents, students, educators. The starting point is the landmark Tinker case. The court famously said students don't shed their constitutional rights at the schoolhouse gate.
So kids do have free speech rights in school.
They do. Schools can't just ban expression because they dislike the message, like the black armbands protesting the Vietnam War and Tinker.
So when can a school restrict a student's personal expression? What's the test?
The Tinker test is, School officials can restrict student expression only if they can reasonably forecast that it will cause a substantial disruption of or material interference with school activities. It has to be more than just making others uncomfortable or starting discussions. It has to actually disrupt the educational environment.
That seems like a fairly high bar for the school. But does that same standard apply to everything students say or write in school? What about, say, the student newspaper?
No. That's where the Hazelwood standard comes in. This applies to speech that is school-sponsored, part of the curriculum, or could reasonably be seen as bearing the school's endorsement, like the official newspaper, school play, etc.
And the rule is different there.
Much different. For school-sponsored speech, administrators have broader authority to ensure the expression aligns with educational goals. They can exercise editorial control as long as their reasons are reasonably related to legitimate pedagogical concerns.
Pedagogical concerns. That sounds a lot broader and easier for the school to meet than substantial disruption.
It absolutely is. It allows schools to control the content and quality of activities done under the school's banner, considering things like age appropriateness, fairness, grammar, or whether it aligns with the curriculum. It's about the school controlling its own educational message, distinct from tolerating students' independent personal expression under Tinker.
Okay, a really important distinction. Let's move to another high-stakes context.
Yeah.
Public employees speaking out. Whistleblowers, critics. What protects them?
This is incredibly complex. There's a multi-part test. First, to even get First Amendment protection, the employee must be speaking as a citizen on a matter of public concern.
Not just a personal workplace grievance.
Correct. If it's about broad issues of public importance, government waste, corruption, safety issues, it clears the first hurdle. Then, the court applies the Pickering balancing test.
Balancing what against what?
It balances the employee's interest in speaking out as a citizen against the government employer's interest in maintaining an efficient, orderly, and effective workplace. Does the speech disrupt operations, undermine authority, harm working relationships?
But there's a huge carve-out before you even get to balancing, right? The Garcetti rule.
Yes, and this is often devastating for employees. Garcetti v. Ceballos held that if the employee makes a statement pursuant to their official job duties, then their speech is not protected by the First Amendment from employer discipline.
Can you clarify that? Speaking pursuant to official duties.
It means if the speech is part of the job you're paid to do. For example, a prosecutor writing an internal memo about misconduct he discovered during an investigation, that was his job. The court said that speech isn't protected because it's considered the government's own internal operations, not the employee acting as a private citizen.
Wow. So if I'm a building inspector and my job requires me to report safety violations, reporting those violations internally isn't protected speech if my boss retaliates.
Under Garcetti, generally no. But if that same inspector sees the violation and, say, writes a letter to the editor of the local newspaper about it as a concerned citizen, that speech would likely be protected, subject to the Pickering balance. It's a crucial and often harsh distinction.
So if an employee does speak as a citizen on a matter of public concern and gets fired, how do they prove the speech caused the firing?
They use what's called the Matt-Healthy test. First, the employee has to show their protected speech was a substantial or motivating factor in the decision to fire or discipline them.
Okay, so the speech played a real role. Then what?
Then the burden shifts to the government employer. They can still win if they can prove they would have taken the same action, fired the employee, for instance, even in the absence of the protected speech. Maybe due to poor performance totally unrelated to the speech.
Got it. A final context point. Symbolic speech, like actions instead of words, and the right not to speak.
Yes, actions can be speech, think, wearing an armband or burning a flag. And just as important is the right not to be forced to speak the government's message.
The classic case being about the flag salute.
Exactly. West Virginia v. Barnett. The court said forcing students to salute the flag and recite the pledge violated the First Amendment. No official can compel citizens to declare a belief. It protects freedom of conscience, the right to remain silent.
And what about actions towards symbols, like flag burning?
The Supreme Court has consistently struck down laws banning flag desecration. Why? Because those laws are inevitably aimed at the message being conveyed by the act, disrespect, protest, dissent. Since the government can't ban speech just because it finds the message offensive, that's content discrimination, flag burning as a form of political protest is protected symbolic speech.
Even though many find it deeply offensive.
Even so, the protection extends to offensive ideas.
Okay, that wraps up the context. Ready for the legal tools.
Yes, Section 5. Let's look at some of the more subtle ways speech is protected dealing with things like discriminatory taxes or overly broad laws. These are important doctrines the courts use to guard the First Amendment, sometimes behind the scenes. First, taxation. Can the government tax the press?
Well, a general sales tax applies to everyone, including newspapers, right?
Right. General taxes that apply neutrally to the press, along with other businesses, are usually fine. But the court looks very closely at taxes that seem to single out the press or target a small group within the press.
Why the extra scrutiny?
Because, as the court said way back in Grosjean, the power to tax can be a powerful weapon to control or suppress expression. If a tax hits only newspapers, or only large newspapers critical of the government, it raises red flags that the motive might be censorship, not revenue. Such taxes face heightened scrutiny and are often struck down.
So neutrality is key. Okay, what about anonymity? Is there a right to speak without revealing your name?
Yes, there's a strong tradition and constitutional protection for anonymous speech, especially political speech. Think of the Federalist Papers or Thomas Paine's pamphlets.
Why is anonymity protected?
Because forcing speakers to identify themselves can subject them to harassment, intimidation, or retaliation from those who disagree, especially from the government or powerful opponents. This fear can chill people from speaking out on important public issues.
So what does this mean practically? Like for handing out leaflets?
It means laws that require pamphlets or leaflets on political or social issues to include the name and address of the author or distributor are usually unconstitutional. The court struck down such laws, saying they could deter perfectly peaceful discussions. Similarly, banning anonymous door-to-door advocacy or requiring registration first often violates this right.
Okay, finally, the overbreadth doctrine. You called it strong medicine. What is it and why is it important?
Overbreadth is a special rule that lets someone challenge a law because it prohibits too much protected speech, even if that person's own speech could potentially be restricted.
Wait, you can challenge a law even if your own conduct wasn't protected?
Yes, that's why it's unusual. Normally, you need to show your own rights were violated. But if a law is written so broadly that it sweeps in a substantial amount of constitutionally protected expression along with unprotected conduct.
Like a vaguely worded anti-protest law.
Exactly. If it's so broad, it might deter people from engaging in peaceful, lawful protests for fear of being prosecuted. The court might strike down the entire law on its face. This prevents the chilling effect, where people self-censor out of fear of an overly broad law. But the court is cautious. The overbreadth must be substantial relative to the law's legitimate scope.
So it's a tool to protect everyone's speech rights by getting rid of laws that cast too wide a net.
Precisely. It ensures laws are narrowly tailored to target only unprotected activity.
Okay, this has been a fantastic deep dive. It really underscores that the First Amendment isn't some simple on-off switch. It's this incredibly nuanced system where the lines are constantly being drawn based on context.
That's the core takeaway. Are you a public figure or private citizen? Are you speaking as an employee or a citizen? Are you in a park, a school, or your own home? Are you using words, symbols, or associating with others? Each context triggers a different test, a different balancing act.
Understanding those tests, actual malice, clear and present danger, substantial disruption, Pickering balance, content neutrality, that's really the key to understanding your rights and their limits in the real world.
It absolutely is. And as we wrap up, here's something to think about, a really modern challenge. Government officials now use social media constantly, often blurring the lines between personal accounts and official duties. The Supreme Court is starting to grapple with this, asking when blocking someone on Facebook or Twitter becomes state action limited by the First Amendment.
So the question is,
if a mayor's personal Twitter feed used for public announcements is deemed a public forum, what does that mean for the millions of posts, likes, blocks, even emoji reactions by public servants online every day? Are we entering a new era where even digital silence or a thumbs up from an official could become a battleground for First Amendment rights? That's the next frontier the courts will have to navigate.